In particular, in this first presentation, we're going to cover sections of 35 U.S.C., Section 102A1, Section 102B1A, and 102B1B. In addition, we'll discuss and explain various terminology used in patent examining that relates to this statute. Some of the terms that we'll define for you are shown on the slide. Lastly, we're going to discuss how to apply the provisions of the statute to claims in a patent application and provide some examples to reinforce the material. Before we begin, you need to be aware that 35 U.S.C. Section 102, as implemented by the AIA, does not apply to all patent applications. It applies only to some patent applications filed on or after March 16, 2013. Patent applications can be divided into two categories: pre-AIA applications and AIA applications. 35 U.S.C. Section 102, as it existed prior to the AIA, is applicable law for the first category, whereas Section 102, as implemented by the AIA, is applicable law for the second category. This series of lectures will only be applicable to AIA applications. Consequently, whenever you pick up a patent application to work on, you need to know which category it falls into so you know which version of Section 102 to apply. So how does one determine which category the application falls into? Here at the USPTO, we have two systems that can help. The first is the Docket and Application Viewer of the Patents End-to-End tool, also known as the DAV Docket View. The second is the Patent Application Location and Monitoring System, also known as PALM. All you need to do is look up the application serial number in either DAV or PALM. In each of these systems, there is an AIA indicator that will provide the information you need. If the AIA indicator says yes, the application is subject to the version of Section 102 we are discussing. If the AIA indicator says no, the application is subject to the pre-AIA version of Section 102. Please note that the AIA indicator applies only to the first inventor to file provisions of AIA. Other AIA provisions, such as those related to oath and declaration requirements, apply to any application filed on or after September 16, 2012. These topics are covered in detail in other modules. This slide shows a screenshot of an examiner's docket in DAV with the AIA indicator column highlighted by the red box. From this column, you can easily tell which applications are AIA applications and which are not. This slide shows a screenshot of the DAV application view for an individual application. The AIA indicator is shown at the top and again is highlighted by the red box. This slide shows a screenshot of the PALM application information page for an individual application. The AIA indicator is shown at the top right and is highlighted by the red oval. Once again, if the AIA indicator says yes, the application is subject to the version of Section 102 we are discussing here. If the indicator says no, the application is subject to the pre-AIA version of Section 102. Now we'll take a look at the first section we will be discussing, 35 U.S.C. Section 102A1. Section 102A1 says, "A person shall be entitled to a patent unless the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention." One of the major duties of a patent examiner is to determine whether those conditions are met for the claims in the application on which the examiner is working. An examiner is only to make this determination once a complete search for the claimed invention is finished. If it is determined that the conditions of Section 102A1 are met for a claim, the claim is said to lack novelty and consequently is unpatentable. In such a situation, the examiner would reject the claim under Section 102A1 unless there is an exception that applies. We'll discuss exceptions later in this presentation. If it is determined that the Section 102A1 conditions are not met for a claim, this means that the examiner cannot reject the claim under Section 102A1. It does not mean that the claim is necessarily patentable or that the application should be issued. Claims are only considered patentable or allowable when no rejection can be made under any appropriate statute. Some of the other statutes that can be used to reject claims are 35 U.S.C. Section 101, Section 102A2, Section 103, and Section 112. We're now going to delve deeper into the language of Section 102A1. Remember, Section 102A1 precludes patentability of a claimed invention when the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. The graphic on this slide shows this visually. So what does it mean to be patented, described in a printed publication, or in public use, on sale, or otherwise available to the public? The term patented in this context means a patent issued in the United States or in any country in the world. The patent does not even have to be in English. Any language will do. Hopefully, you will remember from the previous slides that Section 102A1 talks about the claimed invention being patented before the effective filing date of the claimed invention. From this, we can conclude that there is some date associated with patents that need to be compared to the effective filing date of the claimed invention to determine if the patent can be used under Section 102A1. That date is the patent issue date, that is, the date that patent rights were granted. The category described in a printed publication covers almost every other kind of printed document. Included within the term printed publication are patent applications that are published here in the United States, also known as pre-grant publications or PG-Pub documents. International applications, also known as PCT or Patent Cooperation Treaty applications, that have been published by the World Intellectual Property Organization or WIPO, and any foreign patent applications that have been published. In addition to these, there is a group of documents that we generally refer to as non-patent literature. As its name implies, it refers to pretty much any literature that is not a patent or a published patent application. Printed publications don't have to be in English. The term non-patent literature, or NPL for short, refers to things like books, magazines, journals, newspapers, poster presentations and handouts, advertising, as well as material posted on the Internet. That covers a large amount of documents. Just like for the patented category of documents, there is some date associated with printed publications that needs to be compared to the effective filing date of the claimed invention to determine if the publication can be used under Section 102A1. That date for printed publications is the actual publication date unless there is some evidence to the contrary. This caveat is important because the official publication date of a document is not always the actual date that it was made available to the public. For example, say a magazine itself indicates that it was published on June 15, 2013, but then let's say that evidence comes to our attention that, in spite of the date on the magazine was actually released to the public on June 2, 2013, or maybe June 21, 2013. In situations like these, when you have the appropriate evidence, the relevant date to use for the comparison is the date that the document was made publicly available. Without any additional evidence, the date on the document itself should be taken as the publication date. While non-patent literature does cover a multitude of documents, it does not cover every printed document. For a document to be considered a printed publication, it must have been made available to the public in such a manner so that anyone interested in the subject matter and ordinarily skilled within could locate it by exercising reasonable diligence. Consequently, for example, a printed document that is circulated within a company as a confidential internal document would not be considered a printed publication under Section An Internet posting can be considered as a printed publication as of the date that it was made available to the public on the Internet. Sometimes it can be difficult to find the date that a posting was publicly available, but you need to have evidence of such a date. An electronic publication can be used as a printed publication under 35 U.S.C. Section 102A1 as long as you have evidence that it was publicly available before the effective filing date of the claimed invention. However, if you locate a web page on a given date and record the date you print the web page on it, then that date is sufficient evidence of at least the date you printed that web page for any applications having an effective filing date after that date. There is also a tool on the Internet known as the Wayback Machine. It's available at www.archive.org, and sometimes it is useful in providing the appropriate evidence of public availability for an Internet posting. Remember, the disclosure just needs to have a public availability date before the effective filing date to be employed in the 35 U.S.C. Section 102A1 analysis. So we've covered patented and printed publication. Now we'll move along to in public use and on sale. These terms refer to any act of public use or any actions of putting the claimed invention on sale to the public. In addition, the public use or on sale does not have to teach one of skill in the art how to make and use whatever is being publicly used or on sale under 35 U.S.C. Section 112A. Using a public use or on sale to reject a claim under Section 102A1 is relatively rare, particularly because it is difficult to find evidence of such uses or on sale. When you do get such evidence, it's usually because an applicant or a competitor provides it. Just like the other categories, public uses or on sale can occur anywhere in the world. For public uses or on sale activities, the date that is used to compare with the effective filing date of the claimed invention is the date that the actual public use or on sale activities took place. The otherwise available to the public category is a catch-all category that covers pretty much any public disclosure not covered in the other categories. There is no counterpart in pre-AIA law. This category covers oral public disclosures like a presentation at a meeting, a lecture, or a statement made on a radio or a TV program. YouTube videos, websites, or other online material may also be construed as being in the otherwise available to the public category, even though they may also fall within the printed publication category. It's not critical that you pick the right category for some document or disclosure. You just need to be sure that it falls within one of the categories we discussed. For this category, the date that is used to compare with the effective filing date of the claimed invention is the date that it was made available to the public. Now that we've discussed the various categories of documents, materials, and/or acts that can be used to reject claims under Section 102A1, we want to define a couple of terms that are typically used when discussing such rejections. The first term is reference. Here are some ways that you will hear the term being used. What reference are you using to make the rejection? Or, what does the reference teach? We are not limiting the term to only mean prior art reference, but it can be any of the above noted types of documents or evidence. For patents and printed publications, the word reference is merely referring to the actual patent or printed publication. For the other categories, it is referring to the document or other evidence that is being used to establish an act of public use, on sale, or public availability. The other term is disclosure. In the language of patents, the word disclosure can mean slightly different things depending on the context in which it is used. In the context of Section 102A1, the word disclosure is referring to anything described in a patent or printed publication. For the public use, on sale, or public availability categories, it is referring to the actual act of public use, on sale, or public availability as opposed to the reference used to establish the act. So we've seen this slide before. For reinforcement, I'm going to repeat what I said before. Section 102A1 precludes patentability of a claimed invention when the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. In the next set of slides, we will discuss the meaning of the effective filing date of the claimed invention. Each United States patent application must include at least one claim which sets forth that which applicant regards as their invention. Each of these claims is a claimed invention. Furthermore, each patent application is filed in the United States Patent and Trademark Office on a certain date. That date is known as the actual filing date for each claimed invention in that application. For obtaining such a benefit, right, or priority, the United States patent law also permits applicant under certain circumstances to obtain the benefit of or priority to the filing date of an earlier filed application. In those circumstances where applicant has met the requirements for obtaining such a benefit, the USPTO views the claimed invention as having been filed in the United States as of that earlier filing date. This is the effective filing date of the claimed invention. When applicant does not claim or try to get benefit or priority of an earlier filed application, or fails to meet or get such benefit because the appropriate conditions for the benefit or priority claim have not been met, then the effective filing date of the claimed invention would be the same as the actual filing date of the claimed invention. The statutes that allow applicant to obtain benefit or priority to the filing date of an earlier filed application are 35 U.S.C. Section 119, Section 120, and Section 365. When applicant indicates or states on the record that they want to obtain benefit or priority to the filing date of an earlier filed application, that indication or statement is known as a claim for benefit or priority, or a benefit claim, a priority claim, a claim for priority, and must be made in the application datasheet or ADS of that application. Note that the term claim in this particular context is being used here to mean something different than the claims in an application which set forth that which applicant regards as their invention. Section 119, paragraphs A through D, cover claims for priority to a previously filed foreign application. Section 119E covers claims for domestic benefit to a previously filed U.S. provisional application. Section 120 covers claims for domestic benefit to a previously filed U.S. non-provisional application. In this case, the application would then be either a continuation, divisional, or a continuation in part of that previously filed non-provisional application. Claims to U.S. applications are called domestic benefit claims, whereas priority claims to foreign applications are called foreign priority claims. What is extremely important to note here is that the effective filing date of a claimed invention can now go back to an application filed in a foreign country, whereas pre-AIA law did not allow this. In order for the foreign priority date to be treated as the effective filing date during examination, in addition to the claim or request for such priority, a certified copy of the foreign application must be provided as well as a translation of the application, if it is not in English. This is known as perfecting the right of priority. The last thing that is required to actually obtain the foreign filing date is that the claimed invention must be described in that foreign application in the manner set forth in 35 U.S.C. Section 112A. This means that the foreign application must describe the claimed invention and enable one of ordinary skill in the art to make and use the claimed invention. It is the examiner's responsibility to make this determination for each claimed invention. For applicant to actually obtain benefit of the filing date of an earlier filed domestic application, the application must have at least one common joint inventor with the earlier application. The application data sheet of the current application must contain a specific reference to the earlier filed application, and the claimed invention must be described in that earlier filed application in the manner set forth in Section 112A. Just like in the foreign priority situation, this means that the earlier filed application must describe the claimed invention and enable one of ordinary skill in the art to make and use the claimed invention. Again, it is the examiner's responsibility to make this determination for each claim in the application. You will notice that for both claiming domestic benefit and foreign priority there is a common requirement, which is that the claimed invention must be described in the earlier filed application in the manner set forth in Section 112A. Because of this requirement, different claims in the same application can have different effective filing dates. This can come about when applicant provides a benefit or priority claim, and for example, the earlier filed application describes and teaches how to make and use the invention claimed in Claim 1, but does not describe or teach how to make or use the invention claimed in Claim 2. In this situation, the effective filing date of Claim 1 would be the filing date of the earlier filed application, but the effective filing date of Claim 2 would be the actual filing date of the application. So the analysis for determining the effective filing date of the claimed invention must be done on a claim-by-claim basis. At this point, we're ready to talk about the phrase prior art. You will hear this phrase used quite often, and it's usually qualified with this section of 35 U.S.C. Section 102, as noted on this slide. Using the definition of the word disclosure that we previously set forth for Section 102A1, we will define prior art as any disclosure that also meets the timing requirements for Section 102A1 and for which no exception applies. The next two slides show exactly what is meant by this. Any patent or printed publication that was respectively patented or published before the effective filing date of the claimed invention would be considered meeting the requirements of 35 U.S.C. Section 102A1 relative to the claimed invention. While such documents might be called merely prior art in a discussion, you might also hear them referred to as prior art disclosures or some similar phraseology. Similarly, any act of public use, on sale, or public availability that happened before the effective filing date of the claimed invention would be considered prior art relative to the claimed invention, provided that no exception applies. Such acts can be called prior art disclosures or simply prior art. Again, we want to make a distinction here between the actual acts of public use, on sale, or public availability that would be prior art to a claimed invention and the evidence used to establish the act. It must be noted here that the reference or evidence used to establish the act does not itself have to qualify as prior art, but it must provide enough information to establish that the actual act being relied upon occurred before the effective filing date of the claimed invention. Once again, Section 102A1 precludes patentability of a claimed invention when the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. When it can be shown that the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention, the claimed invention is said to lack novelty, and the prior art used to establish this is said to anticipate the claimed invention. Consequently, in the context of Section 102A1, the phrase, "the claimed invention lacks novelty," and the phrase, "the prior art disclosure anticipates the claimed invention," are equivalent to the statutory language. To further expand the concept, it is accurate to say that a claim lacks novelty when it is anticipated by a single prior art disclosure. So we will define lacking novelty and anticipation as the existence of a single prior art disclosure that teaches at least one complete embodiment within the scope of a claim. It should be noted that claim elements or limitations do not have to be expressly taught in this single prior art disclosure. They may also be inherent in that disclosure. But regardless, all the claim elements must be there in one form or the other. At this point, you need to be aware of the difference between claim limitations and the breadth of a claim. Claim limitations are the individual components required by the claim that together make up an embodiment of the claimed invention. Claim breadth is the full range of embodiments of the invention that the claim encompasses or covers. So for a prior art disclosure to anticipate a claim, it must teach all claim elements expressly or inherently, but it only needs to teach one embodiment within the breadth of the claim. Hopefully the examples on the next two slides will make this clear. In this example, we are examining a claim directed to a composition comprising of an alcohol and oil. The limitations of the claim are an alcohol and oil. During our search, we found prior art that teaches a composition that includes any alcohol and water. The question is, does the prior art reference provide evidence that the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention? In other words, does the prior art anticipate the claimed invention? The answer here is no. While the reference is given as prior art, that is, something that occurred before the effective filing date of the claimed invention, it does not anticipate the claimed invention because it does not teach one of the claim limitations the requirement that the composition includes an oil. While we were examining the same claim as in the last slide, we also found a prior art reference that teaches a composition that includes methanol, which is an alcohol, water, and canola oil, which is obviously an oil. Does this prior art reference anticipate the claimed invention? Here, the answer is yes. This reference is also given as prior art, but unlike the previous reference, it teaches a mixture that meets all the limitations of the claim. Because it is a composition, methanol meets the limitation of alcohol, and canola oil meets the limitation of oil. To anticipate, the reference does not have to teach all oils or all alcohols even though the breadth of the claim encompasses all of them. The reference only needs to teach one embodiment within the breadth of the claim. At this point you might be thinking, but the claim does not require water whereas the reference teaches a composition that includes water. So the reference includes more than what is claimed. If you thought this, I want to commend you because that is a great observation. But in spite of this, the conclusion is the same. The reason is that when the claim says a composition comprising, the word comprising means that the composition includes those things listed as well as anything else. So the claimed composition can include water, and consequently the composition of the reference still falls within the breadth of the claim. Up to this point, we've discussed the language of Section 102A1 and the meanings of the words and concepts set forth in that statute. Now we can begin to bring this together into a process that can be used when examining a claimed invention. The first step will be to determine whether a disclosure qualifies as prior art under Section 102A1. This step involves making sure that the relevant date of the potential prior art is before the effective filing date of the claimed invention. This is done over and over again as you search the art for the claimed invention. If a disclosure qualifies as prior art under Section 102A1, then you move on to the next step and review the file to determine if any exceptions under 35 U.S.C. Section 102B 1A or 102B1B apply. The final step, if there are no exceptions that apply, is to determine if the prior art disclosure anticipates the claimed invention by teaching at least one complete embodiment of the claimed invention, either explicitly or inherently. Again, this is done repeatedly as you find prior art during your search. We will discuss Section 102B1A next. We will begin by looking at just the first part of Section 102B1, which says, a disclosure made 1 year or less before the effective filing date of a claimed invention shall not be prior art to the claimed invention under subsection A1 if. So 102B1A and 102B1B boils down to this. Even though you find a disclosure that would fall within the meaning of Section 102A1, that disclosure will not be considered prior art under Section 102A1 if one of the exceptions in Section 102B1A and Section 102B1B applies. There are two exceptions. One is set forth in Section 102B1A, and one is set forth in Section 102B1B. Of course, we have not talked about the specifics of these exceptions yet, but it should be clear from what we've read in the previous slide that both of the exceptions involve potential prior art disclosures that were made in the 1-year period preceding the effective filing date of the claimed invention. That 1-year period is known as the grace period. This slide illustrates the time periods in which exceptions under Section 102B1A and Section 102B1B may or may not apply to disclosures under Section 102A1. No exception applies to any disclosure under Section 102A1 that was made before the grace period. This is illustrated by the red arrow. So in formulating a rejection, the examiner should, whenever possible, rely on Section 102A1, prior art disclosures made more than 1 year before the effective filing date of the claimed invention. Because the effective filing date is the key to finding the best prior art in terms of its date, it is important to understand the effective filing date of the claimed invention, as we previously discussed in detail. In this slide, the 1-year grace period is shown as the blue bracket. Note, since the language of Section 102B1A and Section 102B1B talks about disclosures made 1 year or less before the effective filing date of a claimed invention. In the slide example, a disclosure having a date of May 1, 2014 would fall within the grace period. This slide provides some visual examples of how a claim for domestic benefit is related to the effective filing date and the grace period. Both timelines concern an application with a domestic benefit claim. Hopefully you remember that to actually obtain domestic benefit, the application must have at least one common joint inventor with the earlier application. The application data sheet of the current application must contain a specific reference to the earlier application, and the claimed invention must be described in that earlier filed application in the manner set forth in 35 U.S.C. Section 112A. In the top timeline, at least one of those requirements was not met, and therefore the effective filing date of the claimed invention is the actual filing date, and the grace period extends back 1 year from the actual filing date. In the bottom timeline, all the requirements for a domestic benefit have been met, and therefore the effective filing date is the filing date of the earlier application, and the grace period extends back 1 year from there. This slide is similar to the previous slide, but in this one, the claim is for foreign priority. You should recall that to actually obtain foreign priority, a certified copy of the foreign application must have been provided as well as a translation thereof if it is not in English. Again, this is known as perfecting the right of priority, and the claimed invention must be described in that foreign application in the manner set forth in 35 U.S.C. Section 112A. In the top timeline, at least one of those requirements was not met. Therefore, the effective filing date of the claimed invention is the earliest U.S. filing date, and the grace period extends back 1 year from that date. In the bottom timeline, all the requirements for foreign priority have been met. Therefore, the effective filing date is the filing date of the foreign application, and the grace period extends back 1 year from its filing date. While domestic benefit and foreign priority are quite similar as indicated in these last two slides, there can be some differences in how this plays out during examination. During prosecution of a patent application with either a benefit or priority claim, an initial determination must be made as to whether the requirements for benefit or priority have been met. For domestic benefit claims, this initial determination usually stands throughout prosecution. But for foreign priority claims, it is quite often the case when this initial determination is made that applicant has not yet perfected the claim for priority by filing the certified copy of the foreign application or the translation thereof. When applicant perfects the claim later during prosecution, the examiner's initial determination needs to be revisited and is altered. How this can affect prosecution and the selection of prior art by the examiner is explored in the next few slides. In the next 3 slides, we will consider an application that has a claim for foreign priority, but where applicant has not yet perfected the claim, and we will look at Section 102A1 prior art that falls into each of the 3 time intervals shown on this slide. Working from left to right on the timeline, the earliest time interval is more than 1 year before the foreign priority date claimed. The middle time interval is 1 year or less before the foreign priority date, and the latest time interval is on or after the foreign priority date claimed and before the earliest U.S. filing date, in other words, an intervening reference. The applicant's options for overcoming a rejection will be different depending on where the reference falls on this timeline. In this slide, the reference indicated in purple has a date that is more than 1 year before the claimed foreign priority date of May 1, 2014. In this case, the reference is outside any possible grace period for this application, even if applicant perfected the right of priority. Thus, from the examiner's perspective, this is the best art to apply in terms of dates because neither a perfected foreign priority claim nor any exception can overcome a rejection based on the reference. This slide shows the reference date in the middle time interval, which is less than 1 year before the claimed foreign priority date of May 1, 2014. In this case, without perfecting the claim for priority, the effective filing date of the claimed invention would correspond with the actual filing date of May 1, 2015. Thus, the reference would apply and would not be subject to any exceptions because it is outside the grace period as measured from the actual filing date. But if applicant later perfects the foreign priority claim, the effective filing date for the claimed invention would shift to May 1, 2014, and the reference would then fall within the recalculated grace period. Once this is done, there is the possibility that applicant could overcome the reference by invoking an exception under Section 102B1A or 102B1B. So while this reference isn't quite as good date-wise compared to the reference in the previous slide, it is still better than the one we will discuss next. Here the reference has the date in the latest time interval, which is between the claimed foreign priority date and the earliest U.S. filing date. In other words, it is an intervening reference. Let's consider the various possibilities. Because applicant has not perfected the foreign priority claim, the effective filing date of the claimed invention is May 1, 2015, the actual filing date. However, in this case, even without perfecting the foreign priority claim, it is possible that the applicant could overcome the reference by invoking an exception under Section 102B1A or 102B1B. Furthermore, it is also possible for the applicant to overcome the reference by perfecting the foreign priority claim. If applicant does that, the effective filing date for the claimed invention would shift to May 1, 2014, and the reference would not even qualify as prior art under Section 102A1, since it would then be after the effective filing date for the claimed invention. While this reference has more of a potential of being overcome by applicant compared to the references in the previous 2 slides, it is still important for an examiner to consider such references. The examiner cannot know what will happen in response to a rejection made with such a reference, and it may turn out that applicant cannot perfect the foreign priority claim or invoke any exceptions. I want to reiterate here that when there is a foreign priority claim in your case, you must search for all applicable references, including those we refer to as intervening art. If the intervening art is the best art to apply against the claimed invention, it should be applied and maintained until Applicant provides the information to establish the foreign priority date as the effective filing date. Applicant invokes an exception under Section 102B1A or 102B1B, or applicant has otherwise overcome the rejection, for example, by amending the claims or successfully arguing that the rejection was not proper to begin with.